अस्सलातु वस्सलामु अलैकुम या रसूलुल्लाह वस्सलामु अलैकुम या हबीबल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ आप सब लोग खैरियत से होंगे। अल्लाह ताला आप सब लोग को सलामत रखे, सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से, ख़ासकर नए आने वाले दोस्तों से गुजारिश है कि मेरे चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। तो आज हम पढ़ेंगे सेक्शन 135। Persons to whom order to is addressed to obey or show cause or claim jury. The person against whom such order is made shall perform within the time and in the manner specified in the order the act directed thereby or B. Appear in accordance with such order and either show cause against the same or apply to the magistrate by whom it was made to appoint a jury to try whether the same is reasonable and proper. Commentary, scope and extent. Section 135 CRPC give the person against whom conditional order is passed three options. Firstly, he must carry out the order. Secondly, he may show cause against the order, or thirdly, he may apply for a jury. These three alternatives as mutually exclusive, showing cause comply with conditional order to the court is gesture of obedience 1997 PCR LJ 1004. Question whether nuisances public in nature or private is to be determined by a competent court on material placed on record. Such question cannot be determined in constitutional jurisdiction by High Court PLD 1998 LAH 353. Mere placement of documents on record is not enough. It is necessary that they should be provided in evidence according to law PLD 1960 KAR 555. The magistrate not competent to drop the proceedings by merely referring to some papers on the file which have not been properly brought on record as provide evidence PLD 1965 D 366. Section 135. Consequence of his failing to do so. If such person does not perform such act or appear and show cause or apply for the appointment of a jury as required by Section 135, he shall be liable to the penalty prescribed in that behalf in Section 188 of the Pakistan Penal Code, and the order shall be made absolute. Commentary, scope and extent. After taking cognizance under Section 133 CRPC and on appearance of the opposite party, the magistrate should not proceed to make the interim order absolute but should act under Section 133 CRPC, which provides that he should take evidence in the matter as in summons case, and if he is satisfied that the order is not reasonable, he should order that no further proceeding should be taken in the case. And if he is not satisfied, he should make the order absolute PLD 1958 KAR 513. Section 137. Procedure where he appears to show cause. First, if the appears and show cause against the order, the magistrate shall take evidence in the matter in the manner provided in chapter 9. Number 2. If the magistrate is satisfied that the order is not reasonable and proper, no further proceeding shall be taken in the case. Number 3. If the magistrate is not so satisfied, the order shall be made absolute. Commentary, scope and extent. Section 133 CRPC lays down the procedure where accused appears and shows cause against the order. It is obligatory for the magistrate to take evidence as in a summon case. It is the complainant to start the proceedings by adducing evidence and then the party showing cause may proceed his own evidence if so advised. After going through this procedure, the magistrate can make the conditional order absolute if he finds sufficient reason for doing so. PLD 1958 for KR 513 regarding of evidence and obligatory failure give rise to serious defect in proceeding. Variation take the whole PLD 1960 KAR 555. Section 138 where he claims jury. On receiving an application under section 135 to appoint a jury, the magistrate shall forthwith appoint a jury consisting of an uneven member of persons not less than 5, of whom the foreman and one half of the remaining members shall be nominated by such magistrate and the other members by the applicant. B. Summon such foreman and members to attend at such place and time as the magistrates thinks fit, and C. Fix a time within which they are to return their verdict. 2. The time so fixed may, for good cause shown, be extended by the magistrate. Section 139 procedure where jury finds magistrate's orders to the reasonable. Number 1. If the jury of a majority of the jurors find that the order of the magistrate is reasonable and proper as originally made or subject to modification which the magistrate accepts, the magistrate shall make the order absolute subject to such modification if any. Number 2, if other cases, no further proceedings shall be taken under this chapter. Commentary section postulates procedure prior to inquiry 1992 MLD 67. आखिर में मेरी तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें और घंटी और लाइक के बटन को दबा दें ताकि मेरी नई आने वाली वीडियो आप तक पहुंच सके।